We'll go ahead and get started. I know I got a few people that'll be joining us here shortly. So today's agenda, we're going to have a hearing on House Bill 2280, and we'll ask Natalie to give us an overview of that bill.
Thank you, Mr. Chairman. House Bill 2280 requires a person convicted of driving under the influence to pay child support for any child of a person who's killed during the offense giving rise to that conviction. The bill creates a new section of law that provides if a person is convicted of involuntary manslaughter during the course of the commission of driving under the influence, then the victim of the offense, if the victim of the offense was a parent of a minor child, then the court shall order the defendant to pay restitution in the form of reasonable and necessary support of each minor child of the victim until each child reaches 18 years of age, or they graduate high school, or the class that they would have been associated with graduates high school. When determining the amount of support, the court shall consider the age of the child, the financial needs of the child, the financial resources and needs of the surviving parent or the state if the child is in state custody, the standard of living to which the child is accustomed, the physical and emotional condition and educational needs of the child's legal custody and residency, and the reasonable child care expenses of the surviving parent. The court shall order that support be paid to the surviving parent or guardian. That order would be able to be enforced as a judgment of restitution, so it would be able to be collected pursuant to KSA 2169. If the person who is ordered to pay this restitution is incarcerated and unable to pay, then that person shall have not longer than 1 year after the person is released from custody to begin payment and create a payment plan to take care of any arrearages. If the surviving parent or guardian brings a civil action and obtains a judgment against that person ordered to pay restitution, then the restitution either will not be ordered if that happens before the restitution is ordered, or it will be offset by the amount of that civil judgment. And I can take any questions.
All right, committee questions. Representative Heiberger.
Yeah, I think you're pretty clear about this. I just want to make sure I understand that this judgment would not be subject to the normal child support collection procedures. Is that?
It would not. It would be entered as an order of criminal restitution and enforced that way.
Okay. Additional Representative Titus.
Thank you, Mr. Chairman. When it comes to the liability for this, would it apply if the person that dies is in the same car as the driver and was also intoxicated?
So you're saying, so essentially when this applies is if a person is convicted of involuntary manslaughter only in the circumstance when they were driving under the influence. So if they were convicted because they killed a driver, or if they were convicted because they killed a passenger, however that happens, but that conviction is a condition precedent.
Well, I mean, yeah, if it's a one-car accident and the passenger, both drivers, well, let's just say Representative Thompson and I split a large bottle of whiskey. We get into an unfortunate one-car accident. Mike is driving. I pass away. Would then Mike have to pay child support?
Mr. Chairman, Representative Titus, I believe that, I mean, that would fall under the provisions for involuntary manslaughter. So I believe that they would, as long as they're convicted of that offense. Yep.
Additional questions. Representative Carmichael.
Thank you, Mr. Chairman. To follow up on Representative Titus's good question. So I take it there wouldn't be a defense based upon the fact that these were joint venturers who are out on a joint venture drinking sojourn, and it just happened to be that one of them was driving and the other one was too drunk to drive and passed out next to him. You pay child support for your passengers, you pay child support for the people you hit in other vehicles, you pay child support for somebody you run over. Is that kind of generally the way this works?
It is, and Mr. Chairman, if you'll allow me just a second.
Sure.
I mean, I know that for manslaughter, it's no defense that the victim and the assailant were engaged in a joint venture. But there were some old concepts, at least in the civil law, that said that liability of one is imputed to the other if it's in fact a joint venture.
Yeah, Mr. Chairman, Representative Carmichael, I just wanted to make sure specifically in involuntary manslaughter, there's no defense of that nature. So barring any other type of normal defense that we have in any criminal prosecution, I think that person could still be convicted and therefore would still be, there's certainly nothing in this section that exempts that kind of situation. So if they're convicted, then they would be eligible.
Okay. The child support or the equivalent of child support that's being paid, is it on an installment basis every month, or that's the first question?
Mr. Chairman, the bill doesn't get into the specifics of that. So the amount would be owed as a total amount of restitution. The only reference to that kind of monthly payment is if the person is incarcerated and then released. They have a year to start paying the arrearages and get put on some kind of payment plan. But I suspect that, the court would, because that is part of your sentence. So the court would make that order of restitution. And then if there was some way for them to be put on a payment plan, because restitution can be put on a payment plan.
So does that mean at the time of conviction, actually at the time of sentencing, excuse me, that the court is going to have to engage in what we do in civil lawsuits when we talk about future damages, take the expected lifetime or the likelihood that a child will reach the age of majority and factor that into the number of remaining years, because not all children live to be 18. And so at least the economist would, I guess, takes that into account. And then there's a time value of money calculation as well that is done. And then the court enters a restitution order for not only the past due, if you will, support, i.e. from the time of the accident until the time of sentencing, but also an order that covers the future support that would have been paid if it were a family law matter on a monthly basis. Is that the way this works, or is the statute actually, or the bill actually silent on how that's accomplished?
Mr. Chairman, Representative Carmichael, the only kind of guidance I can really give you starts kind of at line 14. So that's, it does list the factors that the court is required to consider when determining what amount is reasonable and necessary support of that child. It does talk about, paragraph 3 is the financial resources and needs of the surviving parent. 2 is the financial needs and resources of the child. So it kind of implies that you're considering the future needs until they get to the age of majority, but it doesn't specifically say.
I might disagree with that interpretation, but I understand how you could reach it. The final matter, I think, that I'd like to address is the calculation of the amount of support, particularly as it relates to the resources of the defendant who has been convicted of manslaughter or better. By the way, does this statute include not only manslaughter, but other forms of punishment for death, first-degree murder, second-degree murder, et cetera?
Mr. Chairman, Representative Carmichael, to answer your second question first, no, it's only those convicted of involuntary manslaughter during the commission of driving while under the influence.
So if they're convicted of a more serious crime, they get a free ride. They're not responsible under this statute.
They would not be, correct, responsible.
Now, let me return then to the first question, see if I can get it phrased properly. We look at, part of the equation is the financial resources of the defendant, I think.
Well, and that's
Help
where
me
I
with the
kinda wanted
language.
to stop you there,
Okay.
because actually, you're right when we think about child support, right? We think that's one of the factors that you consider is the financial resources of the parent who's going to be ordered to pay child support.
Right.
But the financial resources of the defendant are actually not in this factor list.
So If I were in family law court and I were to be divorced from my spouse and I had dependent children, the court would, in calculating the amount of support, look to the amount that my ex-spouse could pay, the amount that I could pay. It goes across the graph and the needs of the child. Court fixes the amount. So if I'm a poor, hardworking lawyer and I don't make very much money, I pay less in support. If, on the other hand, I'm a wealthy, I can't remember the right phrase for bail bondsman now, there's a new phrase, I would pay more. But this statute then doesn't factor that in at all.
Mr. Chairman, Representative Carmichael, it does, you'll see starting on line 19, it does take into account the financial resources and needs of the surviving parent, but it does not take into account the financial needs of the defendant.
Right. So if the chairman and I were both driving vehicles, killing the same person, we both would, our income would not be factored into determining how much we owe, even though he makes a lot of money in the bail bond business and I barely make it as a lawyer.
That's correct, yeah.
Okay. The truth is not in me, Mr. Chairman. Thank you.
Wow, are there any other questions? Representative Mon.
Thank you, Mr. Chairman. So neither 215405 or this statute take into account whether or not, who actually caused the accident, right? So I may be under the influence of alcohol, but driving along at the speed limit, going straight down the road, but I'm above the legal limit, and somebody blows a stop sign, I T-bone them, and they die. I'm still responsible under the statute and 215403, 5.
Mr. Chairman, that would be possible. So if you, I know you don't have it in front of you, but for a person to be convicted of involuntary manslaughter, what justifies that crime is the killing of a human being committed, and then you have recklessly a few other ones. The one that we're talking about, paragraph 3 only, is in the commission of or attempt or in flight from an act described in 8-1567, which is driving under the influence. So it does not require that your being intoxicated while driving the car be the reason that the accident happened. If someone else was liable, you could still be convicted.
Yes, and that's what I was getting at. But this statute also doesn't give me any exemption if I didn't cause the accident, but I was under the influence and somebody died.
Correct, it would not.
Okay. All right, thank you.
All right, additional questions, committee? All right, seeing none. Thank you, Natalie. We will welcome Joanna Corbin, widow of Kevin Corbin, to the podium to testify. Welcome to the committee, Joanna.
Hi. Thank you, Chairman. Thank you, committee. I appreciate it. On October 10th, 2020, my life and my children's lives were completely shattered. The lives of 2 other families were completely shattered. We all lost our husbands in what was supposed to be a short drive to go look at some investment property. We discovered later that the driver was intoxicated, almost double the legal limit. The driver didn't stop, he didn't look, he didn't listen, and drove through a stop sign at an unmanned railroad crossing directly into an oncoming train, killing my husband, Kevin Corbin, Troy Hamlin, and Brent Maroney. This incident left 7 children, ranging from ages 2 to 7, without a father. The ripple effects of the grief and devastation and loss have been tremendous. These incredible men were not only the hearts of our families, but they were also the sole providers of our family. The grief and loss has been unimaginable, and that also comes with other challenges. It completely turns your world upside down in every single way. One of those ways being the financial stability of your family. This bill would hold the accused drunk drivers accountable by requiring them to pay child support to their surviving minor children to the parents or parents that they killed until they reach the age of 18. There's no amount of money that will ever bring these men back. However, this bill can greatly assist in bringing the children impacted by this type of horrific tragedy some type of assistance throughout their childhood. And so I would urge you to please vote for this bill.
Thank you very much, Joanna, and very sorry for your loss. Committee, any questions for Joanna Corbin? Representative Carmichael.
Ma'am, I know it's not easy to be here in these circumstances. For what it's worth, I've had the privilege and the duty of representing people in your circumstance as a lawyer in civil cases, and I've seen with my own eyes devastating effects, and so you certainly have my sympathies and condolences. Sometimes it's said, though, that sympathy and condolences alone is not sufficient. I think that's part of why you're here, because there is real economic loss to children when they lose a parent who is the breadwinner. And I think that's what you're here trying to rectify, not for your own benefit, but for the benefit of others in the future.
Correct.
One of the things that occurred to me as I was listening to our reviser's explanation is it looks to me like this bill is limited to circumstances where, one, there's involuntary manslaughter, and two, there's impairment. I can think of instances, though, where, for example, somebody might be traveling 90 miles an hour on the wrong side of a divided highway at 1:30 in the morning with the highway patrol right behind him with flashing lights and runs for 4 miles from the law, but might not have been drinking, might instead have been fleeing from the scene of a crime, or maybe just because they think it's fun to drive fast late at night. And so they may be convicted of manslaughter, and the loss to the children, child or children, is the same whether they were impaired by drugs or alcohol, or whether they were fleeing from the law, or whether they were just totally irresponsible. From your standpoint, would you see anything objectionable if we expanded this type of protection to any child whose spouse died as a result of involuntary manslaughter involving a motor vehicle, or maybe even expanding it to various forms of homicide? From your standpoint, would that be acceptable, or do you think we really need to limit this just to impaired drivers?
I mean, I don't see anything wrong with that. I don't see anything wrong with even somebody who would be impaired boating. Sean and I were talking about that earlier, even just if you're on the water, if it's a boating accident, and, you know, a BUI. I think it's essential to have it with any kind of recklessness on another party that's inflicted on a family that didn't choose this path.
And actually that leads to what the final, I think, finally I'll say the final question for you. We have a lot of people who engage in wrongful conduct that results in the death of a parent who's the breadwinner. And some of that wrongful conduct has nothing to do with driving or motor vehicles. It's just example. Somebody goes out to the shooting range and drinks beer all afternoon and keeps on shooting, and the next thing you know, they end up dropping a firearm, it goes off, it kills their buddy, and that leaves kids. Do you think we should think about expanding this to any circumstance?
I mean, how broad could that go? I mean,
Yeah, I understand. It's a line drawing activity. I'm just wondering, you know, whether we should take it beyond just motor vehicles or perhaps boats or airplanes to shooting ranges, and I can think of a whole host of other things. That's probably a rhetorical question. I appreciate you being here. Thank you so much for bringing this good idea to the legislature.
Thank you. Any additional questions, committee? All right, seeing none, thank you very much.
Thank you so much.
Are there any other proponents, neutral, or opponents who wish to testify on House Bill 2280? All right, seeing none. Oh,
I'm sorry, Mr. Chairman, if I may ask Ms. Scott an additional question.
you may.
Under existing law, would restitution cover, the court can order restitution in this type of situation that would include child support restitution? Is that?
Mr. Chairman, Representative Mon, yes, the court does have the ability to order restitution. I was going to try to find that statute real quick so I can read you the factors if you want, if I could just have.
Well, I can find the statute later. I just wanted to make sure that my thought process was correct. The second question would be, in a first-degree homicide, not a manslaughter case, I shoot somebody intentionally. I know this this bill would not apply, but could the court order restitution for child support in that situation as well?
Mr. Chairman, Representative Mon, yes, the restitution statute that currently exists would provide for the ability for the court to order restitution in the form of child support in both of those instances. The person also, just as a note, would have a civil cause of action for wrongful death.
Okay, thank you.
All right, thank you. Anything else, committee? All right, seeing nothing, we'll go ahead and close the hearing on House Bill 2280. And we will move into final action on House Bill 2021. And we'll ask Natalie to give us an overview.
Mr. Chairman, House Bill 2021 allows the evidence-based program account money to be used on certain children. It requires the Department of Corrections to build data systems, and it also allows for the overall case length limit extensions for certain juvenile offenders.
Questions for Natalie, committee? All right, seeing none, we'll go ahead and get started with amendments and discussion, and I have actually two amendments. So if we want to go ahead and get those both sent out. Technical amendment first. I realize sometimes this takes just a little bit longer to get these emailed out, but just think of all the trees we're saving. All right. Looks like it finally came through here. So the first one that I wanted to discuss, one of the things that we heard when we were debating this bill was the concern that juveniles could be incarcerated for technical violations. And that was a concern, kind of resonated with most everybody. And so my amendment very simply would remove technical violations from the list. And we're on the very last page, page 15, line 18. So we're just going to strike technical amendments for the reasons that a juvenile may be committed to detention. Are there any questions? Representative Titus.
Thank you, Mr. Chairman. Just to enlighten me, could you describe what some examples of a technical violation would be?
Sure, and Natalie might be able to add to this. Technical violation could be you showed up late to a hearing. It could be a whole slew of things with juveniles. You were inappropriate to your probation officer. Things that are just technical in nature. Natalie, do you want to expand on that?
Mr. Chairman, those are good examples. Is when we're dealing with juveniles not going to school, doing those types of things that are required of a juvenile would be a technical violation.
Yeah. And by the way, are there any other questions on that before? And I go ahead and move my motion. Do I have a second on that? Representative Butler seconds. Committee discussion on the First Amendment. Representative Smith.
So, Ms. Scott, would it include a juvenile who continues to refuse to come home at night, continually violating curfew, but, I mean, to the point of not even showing up for school the next morning on a regular basis? Is that a technical violation of?
Mr. Chairman, Representative Smith, sorry. The code doesn't really specifically define exactly what a technical violation is. There is so the definition that's in the code says means an act that violates the terms or conditions imposed as part of a probation disposition pursuant to KSA 382361, and that does not constitute a new juvenile offense. So I think something like staying out all night or not coming home at night would count as a technical violation because that's not a new offense. And it's not a child in need of care violation. So I think that would meet the definition, but I can't be certain.
And that's what I was thinking too, that as long as it doesn't constitute a new criminal action or status offense, then it would only be so if it were part of the direction by the court that the individual maintain a curfew, attend school regularly, et cetera. So that would fall under that, I believe. All right, thank you.
So currently, excuse me, as you read that, it says a judge may commit a juvenile to detention for a violation of probation and for contempt of court. So by removing technical violation. So are there instances where what was just mentioned would still be considered a violation of probation?
Mr. Chairman, so those are violations of probation. But because, the term technical violation is defined and, we're not mentioning technical violations here, the amendment doesn't specifically exclude technical violations. It doesn't say excluding technical violations of probation. So it's hard to be sure actually how that would be interpreted.
I understand. Additional questions, committee? Representative Smith.
Yeah, just in my non-legal mind here, I mean, we're still giving the judges the word is may, and we're still giving them their discretion. If it's an egregious abuse of a curfew or a simple violation like that, we're still giving them the authority. Am I reading that correctly?
Yes, the judge would be able to commit that juvenile based on, how many violations they've had as it goes into the section. But yes, they would have discretion in that instance.
Representative Heiberger.
Thank you, Mr. Chair. Yes, the way I read it, I don't really think the amendment does anything, so I guess I don't have a strong opinion one way or the other.
Any additional comments or questions, committee? Representative Mon.
I'm not sure procedurally if this is the right time or whether it's in discussion, but I might offer a friendly amendment to your amendment to use the language that Ms. Scott suggested and actually say excluding technical violations rather than just striking including technical violations. Because at the moment, if a juvenile fails to appear for a meeting with their probation officer, that is a violation of probation. It's a violation of the orders of probation. And the court, it's more likely to achieve the goals that you're trying to achieve here, because striking this language simply leaves it, it's a violation of probation, whether it's technical or not. I can do what I need to do if I'm the judge.
Representative Smith?
Thank you. And the representative, the amendment that you're suggesting, I don't know. I think, one, we don't have a problem with courts incarcerating kids on a first-time violation. Normally, and you can debate this with me if you'd like, I think that we see that when it's repeat offenses and usually the extreme. That's when we're seeing, because, I mean, frankly, it's a matter of money, right, when you're sticking kids in incarceration. So, and the idea that we're going to completely eliminate that discretion, I personally would argue that we don't want to do that completely. That's my take on it.
Yeah, I have my hesitations as well, and so while I appreciate the friendly amendment offer, I will decline that at this time, and we'll go ahead and stay on the amendment as written. Committee, additional questions or conversations? All right, seeing none, I close on my amendment. All those in favor of the Owens amendment, say aye. Aye. All opposed, no. The ayes have it. That one is adopted. Very good. Sorry, recorded vote. I forgot to look up. Schlingensiepel, Heiberger, Martinez, and Carmichael. All right, the next balloon that I have is already in your inbox. So, you know, I also sit on the Appropriations Committee, and we oftentimes talk about technology and databases not communicating with one another. We often issue mandates specific to this organization needs to work with this organization and needs to work with this organization. But rarely do those organizations, they seek their own solutions to that, and oftentimes do that in-house in their own technology platform. And so, simply put, this in my mind kind of opens up to where there can be an electronic management system that is created that the departments all have access to, but are not necessarily owned by one department specifically. So that the access, the records are still verified within there, and their authenticity is verified, and that they're valid. And so, again, just trying to make sure that we're really encouraging and opening the door for communication. Natalie, did I describe that correctly? I should probably let you describe it. You're better at that than I am.
Mr. Chairman, and this may have been something that I didn't understand maybe when you requested this amendment, so I want to make sure that I got it right. Sure. So the confidential data system would still be under the Department of Corrections, and the Department of Corrections would be required, the agency that's required to come up with that system. But they would be able to contract with another entity to provide that electronic record system. And then I think everything you said about the verification and everything would be accurate. So
okay. Yeah, that's what I was after. I mean, obviously, somebody still needs to, quote unquote, have ownership, but it's the idea that it does not have to be an in-house owned and managed system, that they can contract with somebody else outside to provide and accomplish the goal, because part of what we're setting forth in 2021 is further communication. So that is my amendment, and I move my amendment. Is there a second? Representative Smith. Discussion committee. Seeing none, I close on my motion. All in favor of the Owens amendment say aye. Aye. Opposed, no. All right, the ayes have it. Ayes are Schlingensiepel, Heiberger, Martinez, and Carmichael. All right, committee, moving on to additional amendments and discussion. Representative Smith.
Thank you, Mr. Chairman. I have an amendment, and I apologize, I don't have this in writing, but I was approached right before we came into the committee about the possibility of making this effective upon publication in the Kansas Register rather than upon publication in the statute book.
Okay. Do you care to move that amendment?
Consider that my motion, yes.
Do I have a second on that? And Representative Thompson. Natalie, do you want to explain the difference, just for our newer committee members, what that difference entails?
Sure, Mr. Chairman. Bills that become effective on publication in the statute book, which is kind of the most common effective date, means that the changes in the law will take effect on July 1st. So these changes, as drafted in the bill, would take effect on July 1st of 2023. When we make them effective on publication in the Kansas Register, that is a publication that is put out not a super regular basis, but it comes out more during the session. So it could be a couple weeks after this bill is passed that it would be published in the Kansas Register, and then the law would become effective.
All right, were there questions about that? Representative Carmichael.
Thank you, Mr. Chairman, and I understand this is a well-intentioned amendment, and I'd like to see these reforms go into effect just as quickly as is practical. The difficulty, though, that I can foresee is that without any type of meaningful lead time, it will be difficult for the people responsible to administer these changes in the law to get the policies, procedures, et cetera, in effect to accomplish the law's purpose, to publicize the fact that there is this change in the law. You know, excuse me, as Ms. Scott says, it can be as quickly as, well, literally sometimes the next day after the governor signs legislation, but more typically a week or two. And I'm not sure that gives everyone who has to comply with this law sufficient time to implement it. What I would suggest in lieu of what we're doing here is give the interested parties an opportunity to respond to this idea and perhaps raise it again as a floor amendment if word comes back that, sure, we can accommodate this and take care of it. Or, I hate to say this, defer to our good friends in the Senate. And in the course of testimony there, the question could no doubt be raised, you know, could you accommodate this if it was passed and the governor signed it 2 weeks later? If the answer is yes, then we would go to conference committee. I think we would probably certainly agree to that type of amendment. Or even at the most extreme of circumstances is if we end up in conference committee, as we always probably do, and we find out that we could in fact do this quicker, sooner rather than later, I think the chair and vice chair and the ranking member would probably want to try to advance those ideas there as well. So that's my suggestion, that let's hold off on this good idea and make sure it'll work.
Additional discussion, committee. Representative Smith.
Thank you, Mr. Chair, and I appreciate the comments of Representative Carmichael. That didn't have a lot of time when I was presented this idea to coming in here, so I'll defer to the chair if you want me to withdraw the motion. I think a floor amendment would give us plenty of time to do that. I'll defer to your judgment, though. I'm willing to withdraw the motion if you feel that would be the proper course of action.
Well, I do think that there's certainly some validity. This is a pretty big bill, although it does look like that there are already some timeframes in here. Natalie, can you speak to that?
Thank you, Mr. Chairman, and I'm glad you brought that up, because normally we don't always have these kind of internally drafted deadlines in bills. So I want to make sure that whatever parts Representative Smith is trying to make effective on publication will actually happen. So new section 1, which is the section that requires the Secretary of Corrections and the Secretary for Children and Families to start giving risk and needs assessment to juveniles who might exhibit offending behavior. That doesn't take effect until October 1st of 2023. And so if you wanted that to become effective on publication in the Register, we would need to remove that as well. And then the provisions related to creating the confidential data sharing system, that doesn't actually take place until 2025. So if you wanted that to have to kind of go into effect right away, but, you know, we'd have to change that. But the parts related to the detention caps, the detention sanctions, and the overall case length limits right now are just July 1. So changing it to Register would accomplish that.
All right, well, that kind of helps open my perspective a little bit. So really, there's not necessarily any agency dialogue that needs to be put together. It would just be a notification to the judiciary, members of the judiciary of the change of statute from the extension of timeframes and the detention and things like that. Representative Heiberger?
Yeah, I would just say that those things just aren't self-implementing. I mean, they all need education and information to get out to various people in the system. I don't think those happen in a week or two.
Okay. Well, yeah, let's discuss this further. I think that that's a reasonable approach, understanding this. And if we do decide further, we can bring it on the floor or in conference or somewhere along that line. But we want to discuss that one further. So if you're good withdrawing.
I will officially withdraw the motion then.
Okay, very good. Thank you very much. And the second is good? Okay, thank you very much. All right, committee, additional amendments or discussion on House Bill 2021. Representative Heiberger.
I understand that I have several amendments. Yeah, that'd be fine.
Mr. Chair, if I might, while we're distributing this, I want to confess to the committee that I was the person who requested these amendments at the instigation of some other people. But I spent quite a bit of time last evening studying President Biden's speech, and I just wasn't feeling quite up to it all today. So I appreciate the ranking member bailing me out.
I could completely understand not feeling up to anything after listening to him speak. All right, looks like they finally hit our inbox. What was the title of the one you wanted to address first?
I think it was detention caps, but mine haven't arrived yet. So.
All right.
Yes.
You care to explain your amendment?
Yes. Basically, my understanding of the amendment is that it strikes the sections in removing detention caps. We heard testimony when we were going through the process of adopting SB 367, and we heard the same testimony again when we heard this bill, is that the evidence is pretty clear across the board that increased detention results in decreased bad outcomes for youth. And we heard a lot of anecdotes about bad results that are happening out there. I'm sure that there are. I mean, I don't doubt the testimony at all, but we did not have any data to really supported this change. So I would move that we strike those detention caps as set out in the amendment.
All right. Sure, go ahead and clarify, and then I'll look for the second.
Yeah, I just want to clarify. So right now in current law, the cumulative detention cap is 45 days. So a juvenile can't be sent to detention for more than that over the course of their entire case. This bill proposes to change that cap to 90 days. It doesn't totally get rid of it. I just wanted to make sure that was, and then, so what this amendment would do is put it back at 45 days.
Thank you, Ms. Scott.
Very good. Do I have a second on the Heiberger Amendment? Representative Carmichael. Discussion on the Heiberger Amendment. Representative Carmichael.
Thank you. Just to make it clear, what this does is it preserves the existing law with respect to the cap rather than doubling the number of days as is proposed in the bill. That's what I understand that this does.
Further discussion, committee? Representative Smith.
I think this was a key consideration in putting this bill together. And, you know, one of the things that we need to be cognizant of is that we're not mandating a doubling of time, but we're providing that discretion to the courts again to use it. And I think that was the whole purpose of putting the 90 days in, and I'll be voting against this amendment.
Further discussion, committee? All right, seeing none, all in favor of the Heiberger Amendment, say aye. Aye. Opposed, no. No. Noes have it. Noes do have it. Those requesting to be recorded as ayes are Carmichael, Martinez, Heiberger, Schlangensieben. Very good. Next one, sir.
Let's go to detention sanctions.
Would you care to explain?
With the caveat that Ms. Scott backs me up and corrects me when I'm wrong, this removes the additional, I guess we called it quick dips in the adult world, the provision for some short sanctions in detention as a additional juvenile sanction. And this would remove those sanctions. Did I miss anything that way?
Very good. Do I have a second on the Heiberger Amendment? Schlangensieben, seconds. Discussion, committee.
My argument basically goes back to what we said before. There's just the evidence is across the board that increased detention results in bad outcomes, and we have not seen any data since the implementation of SB 367 to contradict that. And so I would ask that we remove them.
All right, committee, additional. Representative Smith.
And I'm just going to go back to what I said before. This was also another one of the main imperatives, I think, of presenting this bill to begin with. We had closed down that discretion to some degree, and this was a way of providing another tool for the courts, and I will be voting against this amendment.
Further questions, committee? All right, very good. Representative Heiberger, you can close.
I move my amendment.
All right, all in favor of the Heiberger Amendment, say aye. Aye. Opposed, no? No. Noes have it. All right, those recorded as ayes, Schlangensieben, Heiberger, Martinez, Carmichael. And your third one.
I'm going to decline to run the third one, but if one of my esteemed colleague would like to do that, he's welcome to.
Very good. Are there any additional amendments or discussion as it relates to House Bill 2021? Seeing none. Do I have a motion as it relates to House Bill 2021? Representative Smith.
Thank you, Mr. Chair. I move that we pass HB 2021 as amended favorably.
Do I have a second? Second, Representative Mon. All in favor, or are there any additional discussion? All right, seeing none, all in favor of passing out House Bill 2021 as amended favorably, say aye. Aye. Opposed, no? The ayes have it. Those wishing to be recorded as no, Schlangensieben, Heiberger, Martinez, Carmichael. All right, committee, I believe that wraps up our work for today. So with that in mind, we will be adjourned. Thank you.